So if you admit that, so I said that don't do it. So if in 2013 this interoperable criminal justice system would have been implemented and amendment was made, proposal was made, amendment would have been made, it would have been a disaster because the technology was not ready, the platforms were not ready, trained human resources not there. Even today also I don't think there is enough trained human resource in the rural parts of the various administrative departments who can manage this technology-based system. Very close to my university, the National Forensic Science University's Goa campus is there. And the Forensic Science Department of Goa, they are hiring their professors and their postgraduate students to help them in assisting them in collecting investigation, because you have written in now BMS and Evidence Act that every crime scene investigation has to be recorded. And these people don't even have. But at this sense prevailed, they said my mobile phone. So if it was implemented in 2014, it would have been a disaster. But at least now, at least 70% it can be operated. So again, all these audio-visual things and all, it is also not new. It is over a phase of time that it was happening. The most important change, or the most fundamental change for me, is this electronic communication. I have listed about, there are 1, 2, 3, 4, 5, 6, 7, 8, 9 sections of the Bharatiya Nyaya Sanhita where offences now can be committed in the through electronic communication. The most important is sedition-related provision. What is that? When you hatred speech for religion, what you call it? The blasphemy. Blasphemy. The worst thing that happened during COVID, which all were victim, what do you call? The worst thing that happened in COVID every day. How do you test? When in March COVID came, the first thing, at least every mobile there was a video coming. Other than that, all over India there was a liquor ban. Videos apart from liquor ban, the most important video that started coming is hold your breath for 20 seconds. If you can hold your breath for 20 seconds, you know 100% you don't have COVID. Who is saying this? Now this is what? Fake news. 80% of social media news are fake. Those of us who stay outside Bengal, 80% of messages we get scared. What is happening in Bengal? But then we come to know it is all fake news. Mithun Chakraborty died. And then next day I saw in the television he is very much alive and he's, talking before people. But everyone in India came to know Mithun Chakraborty passed out. This should not be penalized. So now BNS included that, electronic communication, spreading all this. So all these provisions, I don't want to read due to paucity of time, but all these forms of communication, blasphemy, sedition-related, anything that spreads hatred, this kind of false news, everything, electronic communication mode, if it is done, it is going to be considered now a crime. Sorry, it is to be regarded as a crime. Now, reacting to that, is it something irrelevant? Is it something not required? And today, you tell me, how many of you read newspaper? So, whatever news you get, what is the medium? Anyone? Please tell me, hand up. All the news that you get about the world, how many of you get it from newspaper? How many of you read Anandabazar Patrika every day, which you used to do? How many of you read Times of India every day? How many of you? You are, madam, my generation. I am asking to the people who are sitting behind. I also do that. But on a move, Sarfaraz the purchased on Times of India today from Kolaghat. So now he is not this generation, na? We still. But they are leading on their life only on one media, that is social media, and that too one thing, phone, mobile phone. Everything is done now with that. Your reading is done, your entertainment is done, your payment is done. I don't know what else can be done by that. Next. So is it wrong, or is it not right, or is it not timely? And therefore, how can you bring it unless you change those things like documents, evidence, the definitions of that? So necessarily, don't you think? So in BSA, Bharatiya Saksha Adhinayan, the definition of primary document, there is an explanation added, which says, can be considered as a new, if any electronic or digital record which is created or stored, storage occurs simultaneously and subsequently in multiple files, if videos recording, etc. So this, or the scope of secondary evidence. Is it wrong? Don't worry, I will give you. I have already sent it. So it is already available to your professors. Right? So don't need to take photograph. You can use that for some other purposes. Not at least for taking picture of my PPT. So therefore, all this you can see was required. And they were brought. I am not talking about other things, which many of my earlier speakers have pointed out. I have no idea, and I don't want to get into that debate whether it was right or wrong. But at least the technology-oriented things, they were long time visualized. And first time this was visualized by the Supreme Court, very important case, Base Bakery, in Jahira Sheikh's case, sometime in 2002, where Supreme Court said, why do we need to wait for the witness to come when we can do a VC call? So today, prosecution witness, production, identification, FIR, records, cross-examination, every process, section 530, if I am correct, I'll tell you. Section 530, which says that everything of trial, what can be conducted through electronic mode, section 530 of BSS said, trial and proceedings to be held in electronic mode. All trials, inquiry, proceedings under section under this Sanhita, including issuance, service, execution of summons, warrant, examination of complainant and witnesses, recording of evidence, inquiries, trials, appellate proceedings, everything through VC mode. Now, before Supreme Court in 2016 or 17, one petition was filed and said that, see, one of the area where delay happens is that this is to be determined, whether the evidence that was, documented is actually the right evidence or wrong evidence, or many times the appealing party says that this is not what the, witness deposed, the judge took it wrong, all these issues. What is the problem? You have a computer in every judge's office since 2013, part of the first project of e-courts. Why don't you use that computer and record the witnesses? What was the response of Supreme Court? Supreme Court is honorable. Honorable Supreme Court. No, we are open court. So everything is open. That Supreme Court, when COVID came, was compelled to introduce VC. And after COVID, now they realize that this is better. And Justice Chandrachud says, electronization is the need of the hour. His predecessors in 2015 said, Justice Satasivam, that we are open courts. So everything is open. Parliament is not open. So that's why they have to record, and then recordings are telecasted. We are open court. Anybody can come. But we know it is more difficult to enter the Supreme Court than entering the Parliament. Otherwise, terrorists would not have planted to go to Parliament, but could have gone to Supreme Court. That's a joke, don't worry. Okay? So COVID was a lesson. So therefore, the technology now that you see in this, and very importantly, recordings. So appellate proceedings, recordings can be presented. Now only one concern is there, which is this, e-registration, digital evidence, summons, criminal investigation, which is to be recorded, creates a huge data bank, huge. How do you ensure that this data is not, the data privacy is not negotiated? So what is required, therefore, that the Supreme Court and the government leads to more protection of data, more protection in relating to the platforms they are using for this, train and give proper resources to these, personnel who are going to be involved, so who are going to collect these, pictures of the crime scene, who are going to record these witness statements. Everything is now audiovisual, and it is actually better because there is a statement that all these offensive complaints that are said during investigation can be now negotiated by having a video mode recording of the statement recording, or investigating officer recording the statement or confession of the accused. This will prevent them from being oppressed. But at the same time, this huge data that will come, how do you protect? How do you see? One issue that I would like to say, a complexity. What about summons or warrants can be served by using social media mediums? Can social media mediums, for example, I'll give you an example. It was not a criminal case, it was a civil case. But this person was never found in his house. Whenever the process server was to go to deliver the summon, he was not available. But he was completely active in Facebook. He was completely active in WhatsApp. So the court said, paste on his Facebook wall. That is also a wall. And considered that as a service. So today that is possible. And it is not that BNS only said it. In 2017, first time, as I said, part of our initiative from our project, when this question came, email-based service, or fax-based service, whether it is possible. Supreme Court in this Krishnavani Nigam versus Harish Nigam said, yes, possible. And that was reflected in the recent judgment of Punjab High Court on Amar Singh in 2023, where Punjab High Court for tax matters said even by WhatsApp, Telegram, or Signal, or whatever these social media posts, if a person is active and you put it, it is done. And it is now part of the guidelines of Punjab and High Court, which has been adopted by many High Courts. It's 2 minutes, I'm finishing. So, technology's presence is important. And technology's presence has to be taken maximum advantage of. That will only help in addressing the problem. So finally, I want to end with this very important question. 3 very important personnels were present at the time when the bill was presented. And this is what a question to my mind, a deliverance of future. Our Chief Justice saying when the VMS was introduced, watershed moment. Our Home Minister who presented it said it is nyay, not dand, which I said. And our leader of opposition at that time, not now, or in Rajya Sabha, I think he is still the leader of opposition, bulldozer's justice. Now who is correct? That time will tell. For now it is a question mark. But what has been given to us, we should try to do as much possible fairly implement it. And when problems will come, let's see, we'll address. But immediately if we stop and block our mind saying that it's a bulldozer's justice, I don't think for a law person it is appropriate, at least to the technology aspect. I cannot say about other provisions, but at least to the technology aspect, for me, you will see at a time later that whether it is a bulldozer's justice or it is actually a watershed moment. So I leave you with this question mark, which is maybe 10 years down the line, if we have another seminar like this, where actually we can address this question, issues and challenges, and because now it's not time for us to understand what are the issues and challenges. All these, in my opinion, speculation. So actually deciphering the issues and challenges is after 10 years. So hopefully after 10 years, if I'm alive, You will all be alive. If I am alive, we will probably meet and then we can discuss about the challenges and issues. By that time, thank you all.
Thank you, sir, for such an invigorating speech. Of course, sir. Of course, sir. They thoroughly enjoyed your speech. A gentle reminder to the paper presenters, precisely 10 minutes have been allotted for paper presentation. Now I would like to call Dr. Pradipta Bormon, Assistant Professor of Law, Bimal Chandra College of Law, to come to the podium and present his paper on the topic Cyber Forensics in India, Changing Role under Indian Post-British Criminal Law.
Very good afternoon to all the dignitaries present in the dais, all my respected sirs, whom I know from my early days, and all the dignitaries not in the dais, and my dear students. Today, my topic is on cyber forensic. The term cyber forensic came into existence in late 90s. Before that, it was known as computer forensics. And this term has been introduced in USA, USA forensic science experts, and then it is British forensic science expert. They introduced or coined the term as cyber forensic. And as I am also a positive person, so our new criminal law, that is BSA, BNSS and BSA, 3 new laws, and before that the Information Technology Act and Personal Data Protection Act. Those are the 4 acts. I think that this is a landmark 4 act to overcome from colonialism. And as a supporter of the post-colonial laws, I am very happy that these 3 new laws has been introduced. The concept of cyber forensic is involved that identification, documentation and interpretation of computer media for using them as evidence and to reveal the crime scenario. Sometimes ago, we know that by using AI, we solved some criminal problems or we solve some criminal act. So computer forensic brands several overlapping areas, generating various terms such as digital forensics, data forensic, system forensic, and network forensics, email forensic. These forensics are very hyped in modern days because the forensic systems allows the administrator to diagnose the error. Intrusion detection systems are necessary in avoiding cyber crimes, and change detection can be possible within proactive forensics. For these 3 reasons, the cyber forensic term is hyped in nowadays. The concept of cyber crime as emerged from various use of the technologies in modern days. Mainly there are 5 types of cyber crime we look nowadays, that is illegal access, that is known as hacking or cracking, that is erotic material or pornographic material, other thing is child pornography, next thing is cyber stalking, other thing is botnet attack and phishing. These are 5 cyber crimes that is more happened in nowadays. On top of that, now we came in the post-colonial, that is BNS implication, cybercrime. First of all, in BNS, they introduced in section 111 the term organized crime. In that organized crime, the cybercrime is defined. Next, in section 294 of BNS, section 77, section 303, section 78 of the BNS, section 317, 318, 336, 356, and 194. That just said, told that there are some sections relating to hate speeches, some sections relating to cyber theft, some section relating to data theft, some sections are relating to the offenses of cyber activities. Next, BNSS implication. Said just told that the audio video communication or electronic communication or recording of search and seizures procedure has been recorded. Previously that was not there. Then it is the implication of BSA where the electronic records has been recognized as a primary evidence. Then the implication of Digital Data Protection Act 2023, which introduced or which solve the concern of us relating to our personal data. Then implication of Information Technology Act, there is section 43, section 66, 66A, 66, 66B, C, D, E. Those are the sections relating to the cyber, to combat the cyber crime. What are the challenges? Then the main topic is what are the challenges the cyber forensics faces. First of all, some facilities are there within the browser for the purpose of saving www pages to the disks are not perfect because it may save the text but not related matches, which we saw just in the OMR sheet case, OMR sheets in the West Bengal job scam, that is SSC scam case. The images are not stored in the disks. Next, the challenges are there might be difference what is there on the screen and it is what is saved on the link. That is the screen link and the saved link, both are two different things. Third problem is that the method which can be used to save particular file might not carry the individual revealing regarding when and where it was obtained. Such files can be easily forged or modified. That is, Justice said that there is a particular system, that is, there is certain apps that can modify the saved documents, that saved file. That is very much concerned to us. Then many ISPs use proxy server in order to speed up their delivery pages, which are popular on web. Hence, the user might not be sure of what he has received from a particular website by his ISP. That is the ISP fraud. Those are mainly the challenges the cyber forensic have. Then my recommendations are, firstly, enhance the cyber security infrastructure. That is, cyber security infrastructure enhancement means advanced encryption process, multi-factor authentication process, and regular security audits. Those are three things. Multi-factor security is now been introduced in the banking sector, but I feel that more multi-factor authentication must be there in various fields where the internet is used. Then cyber security training awareness. Mainly two types of training awareness must be there, that is employee training awareness and customer education awareness. For the employee training awareness, the level latest security procedure must be followed. Then the advanced monitoring and detection system, that is the IDS, intrusion detection system, must be there in all the sectors that is used in internet or others. Next, the regulatory and compliance measure. There are two types of regulatory measure we can introduce. First of all, strict regulatory framework by using certain laws, and second, penalties for non-compliance, and the penalties is immediate penalties, not that penalties be given in future in 5 or 10 years back, not that, immediate penalties. Next, the conclusion, the future of cyber forensics in Bharatiya Land Samhita looks promising for my, according to my opinion, and we can expect more such types of law to enhance these types of cyber forensic. Then in the field of AI and others, we need more such like law that can be colonial law, that may be anti-colonial law, but we need laws to detect the criminal and to stop these types of cybercrime. Thank you all. ये कोई ये तो কারসারি দেখাচ্ছে না কারসার শো হচ্ছে না
খুলে নিয়েছে
না না
খুলে নি।
Thank you, sir. Now I would like to call Mr. Akrit Shah and Ms. Snehashri Goswami, students of Haldia Law College, to come to the podium and present their paper on the topic Handcuffing under BNSS, Reforms or Overreach.
কি হচ্ছে আরেকটা ল্যাপটপ রেডি থাক রেডি সেই ল্যাপটপটা কই যা নিয়ে এনে সেটা নিয়ে এসে এটা সময় লাগবে
I apologize for the interruption. There has been a small technical glitch, so please bear with us.
আপডেট তো করা থাকে
A very good afternoon to all the respected dignitaries, our professors, and one and all present here. I am Akrit Shaw.
I am Snehashi Goswami from Haldia Law College. Today, we'll be discussing our research paper on handcuffing under Bharatiya Nagarik Suraksha Sanhita with a specific focus on the use of handcuffs and whether it is a reform or an overreach. During this presentation, we will delve into the implications of these new provisions, discuss relevant case laws, and explore their potential impact on our legal and societal framework. Let us start by looking at the legal landscape surrounding these issues. Introduction. To begin, let's define what we mean by handcuffs. According to Encyclopedia Britannica, handcuffs are instruments for securing the hands of the prisoners. Now, let us go back and see how the British colonialism influenced the use of handcuffs. Handcuffs then was not only used for security, but as a means to dehumanize individuals. Despite India's independence, the colonial legacy continued to influence our legal framework through the Indian Penal Code and the Criminal Procedural Code. Even today, handcuffing is a topic of significant legal and ethical debate, especially in the context of the new BNSS. Colonial legacy to modern restraints. Handcuffing, a controversial practice in India since colonial times, has been vastly criticized for violating fundamental rights, particularly enshrined under the Article 21 of the Indian Constitution and the Human Rights Commission. Initially, it was used as a tool of oppression. Its symbolic power was not diminished even after the post-independence era. Handcuffing as a punitive versus a preventive measure. Under the BNSS, specifically under Section 43, subsection 3, handcuffing is permitted based on the nature and the severity of the crime. For an example, murder, rape, habitual offenses, organized crimes, etc. However, if one views this provision through judicial lenses, it is seen that there is a drastic shift from the sole purpose of the usage of handcuffs as a preventive measure to using it as a punitive measure. For reference, in the landmark judgment of Prem Shankar Shukla versus Delhi Administration, 1980, the Honorable Supreme Court ruled the preventive measures do not inherently require handcuffing. This also gives rise to the question on the legal maxim, innocent until proven guilty, where there is a shift in parody in terms of necessity of the handcuffs used for the security purposes. Ethical and legal perspectives of handcuffs. Ethically, the use of handcuffs as a preemptive punishment raises significant concerns. It violates the presumption of innocence, effectively branding individuals as guilty in the public at large. Legal judgments have also reinforced these stances. For an example, in the landmark judgment of Sunil Batra versus Delhi Administration, 1978, the Honorable Supreme Court emphasized the humane treatment of all individuals, even those who are convicted. In various other landmark judgments, handcuffs were seen as a gross violation to human dignity of individuals, such as seen in the case of Citizens of Democracy versus State of Assam.
Inconsistency in application. Section 43 of Bharatiya Nagarik Suraksha Sanhita introduces a significant inconsistency in application of handcuffing. For instance, in a case of grievous hurt, an offender is considered as dangerous as any other who has committed a heinous crime. But under the provisions of Section 43, subsection 3, a person who commits a grievous hurt does not fall under the ambit of handcuffing, highlighting a critical inconsistency in the application of handcuffing. Presumption of innocence and public perception. Handcuffing individual based on solely suspicion of committing a heinous crime fundamentally undermines the principle of innocent until proven guilty. However, by imposing handcuffs, on individual based merely on a suspicion that he is involved in a heinous crime, there is an implicit suggestion of guilt. This practice not only contradicts with the principle of innocence and also prejudices the individual's right to fair trial. It is to be noted that in the numerous occasions, the Honorable Supreme Court has underscored the significance of maintaining the presumption of innocence. In the landmark judgment of Narendra Singh versus State of Madhya Pradesh, 2004, the court ruled that undermining these presumptions, such as prejudicial public display or media coverage of suspects in handcuffs, are unconstitutional, as there is an implicit suggestion of guilt. International outlook. India, as a developing nation, needs to align with the standards of international human rights. But the persistent use of handcuffs in India, as codified under Section 43, subsection 3 of BNSS, is inconsistent with these human rights standards, such as Mandela Rules and European Convention for Human Rights. Interestingly, British, who introduced the practice of handcuffing during the colonial era, have moved away from this approach, advocating for the restraints only when justified by the circumstances. It is to be noted that Article 3 of European Convention prohibits the practice of handcuffing and have deeply influenced the courts in UK to ensure that restraints like handcuffs are only used when absolutely necessary. This shift aligns with the global practices and respect of human treatment. This alignment would not only enhance India's commitment to human rights, but also honor the principles of dignity and justice that are central to our legal system. To conclude, India has significant strides in replacing colonial era laws with modern statutes aiming to align the legal framework with modern India and its contemporary values. However, despite of these reforms, regressive practices such as use of handcuffs continues to be persistent. This brings us to a critical question. Does modern India truly need archaic practices to maintain law and order, or there is a growing disconnection between legislative intent and our new laws and their practical implications on the ground? These are the questions that one must consider as we look towards our future. In the next slide, we'll explore the hypothesis that seeks to bridge this gap and proposes a more effective and a human approach to the law enforcement. This research proposes that application of handcuffing should be considered as a preventive measure in Indian criminal justice system and must be approached with extreme caution to hold the dignity of individuals, even those who are accused of heinous crimes. Judicial precedents from Honorable Supreme Court of India have consistently underscored the precedents of individuals' dignity, establishing that handcuffing should be a rare exception rather than a routine practice. This study hypothesizes that handcuffing, if not justified by a clear and present danger of escape, risks devolving into a punitive measure, such as misuse could erode the principles of justice, fairness that the legal system is designed to protect. Thank you.
Due to paucity of time, we are merging technical session 2 and technical session 3. So now I would like to call Ms. Yasmin Khatun, Learned Advocate, Calcutta High Court and Howrah District and Sessions Court, to come to the podium and present her paper on the topic, highlighting the significant changes incorporated in BNSS and overview.
Good afternoon, everyone on the dais, of the dais, and thank you, Haldia Law College, for providing me this opportunity to present my paper here. And thank you, Pratim sir, to call me here and giving me this opportunity. I feel blessed to come here again and again, and be in connection, contact, bolte pari, with this law faculty as well as students, because coming to college it feels like I'm a student again. So সকাল থেকে যা আজকে আমরা শুনলাম, যারা স্টুডেন্টস এখানে আছো সবাই বসে যদি শুনে থাকো সিরিয়াসলি তাহলে অনেক কিছু শেখা হলো। তো যারা পেছনে বসে এখনো গল্প করছো তারা কি মনে করো কিছু শিখলে আজকে? শুধু একজনই বললো, বাকি কেউ তো আর কিছু বললো না। বলো, শুধু গল্প করলে পুরো দিন না শুনেছো? আমরাও ওখানে ছিলাম, ওই পারে আমরাও ছিলাম, তো শুনেছো তো? তো আমি থ্যাংক ইউ বলতে চাইবো আমাদের গেস্ট যারা আজকে এই সাবজেক্টটা এত সুন্দরভাবে এক্সপ্লেন করলেন। মানে এই মানে একটা এনফোর্স হওয়ার আগেও অনেকগুলো কনফারেন্সেস হয়েছে আর পরেও হচ্ছে, বাট এটা আমার ফার্স্ট কনফারেন্স যেটা আমি অ্যাটেন্ড করছি আমাদের ক্রিমিনাল মেজর অ্যাক্টস নিয়ে। তো আজকে যেটা আমি ফিল করলাম কি মানে একটা ব্রেইন স্টর্মিং সেশন যেখানে সব কিছুই ইন আ নাটশেল আমরা শিখলাম আজকে বসে। তো সেই জায়গা থেকে আমি আমার পার্সপেক্টিভ যেটা রাখতে চাইছি সেটা হচ্ছে কি কোর্ট প্র্যাকটিসের দিক থেকে, কি এই যে ল আমরা আজকে পেলাম মেজর অ্যাক্ট, সেই মেজর অ্যাক্ট আমাদের ক্রিমিনাল প্র্যাকটিসে কিভাবে হেল্প করছে, আর আগে যে ল ছিল এক্সিস্টিং সেটা কিভাবে মানে প্রবলেম ক্রিয়েট করছিল, মানে আমাদের কোথায় প্রবলেম হচ্ছিল সেগুলো কিন্তু আজকে গোটা দিনে আমরা শিখেছি। যারা অলরেডি কোর্ট প্র্যাকটিসে যাচ্ছ বা ইন্টার্নশিপ করছো তারা ফিল করবে, বা যদি সিরিয়াসলি ক্রিমিনাল সেশনসগুলো শোনো বা সিভিল সেশনসগুলো শোনো কোর্টে গিয়ে, তাহলে তোমরা ফিল করবে কি একটা সামান সার্ভ করা কত টাফ। 3-4টে ডেট বেরিয়ে যাচ্ছে যেখানে আমরা দেখছি কি স্যার যেটা এক্সপ্লেন করলেন কি এখন হোয়াটসঅ্যাপ ফেসবুক থেকে সামান করা যাচ্ছে, বাট আগে বেলিফ নিয়ে যেত আর ওখানে ম্যানেজ হয়ে যেত এনি হাউ, আর এসে রিপোর্ট দিত কি দ্য পারসন ওয়াজ নট ফাউন্ড। তো এটা ছিল স্ট্রাগল আমাদের, যেটা আজ পর্যন্ত চলছিল, আগে কি হবে সেটা জানি না, বাট স্টিল এখন আমরা চ্যালেঞ্জ করতে পারি কি যেহেতু আমাদের অ্যাক্টের মধ্যে আছে কি এটা করতেই হবে। আর অনেক সময় আমরা মানে এখানে জাস্টিসরা আছেন, বাট বলবো অনেক সময় কোর্টও খুব রিলাক্টেন্ট কি প্রভিশনের মধ্যে থাকলে আমরা চ্যালেঞ্জ করতে পারি, কিন্তু প্রভিশনের মধ্যে না থাকলে আমরা চ্যালেঞ্জ করতে পারি না। অনেক সময় কোর্ট আমাদেরকে প্রশ্ন করে কি এটা কি করে বলুন তো, কোথায় বলা আছে যে আমি এটা এনফোর্স করব? তো সেভাবে অনেক সময় আমাদের কাছে নো আনসার, ক্লায়েন্টকে আমরা রিলিফ দিতে পারছি না। রোজ ক্লায়েন্ট আমাদের কাছে আসছে কান্নাকাটি করছে, বাট উই ডোন্ট হ্যাভ রিলিফ না হওয়ার কারণ যেহেতু প্রভিশন বলছে না। আমরা এগিয়ে যাচ্ছি টেকনোলজিক্যালি টেকনিক্যালি, কিন্তু বাট আমাদের প্রভিশনসগুলো সেই কলোনিয়াল টাইমের প্রভিশন, যার জন্য কি বলুন আমরা ফেস করছি আজকে। তো বিএনএস যখন আমি নিজে যখন পড়ার পর যা নতুন টেকনিক্যাল চেঞ্জেস আমি নোটিস করে আমি খুব খুশি হলাম। আমি বলতে চাইবো কি আমি ডিস্ট্রিক্ট লিগাল সার্ভিস অথরিটির সঙ্গে যুক্ত, আমি মিডিয়েটর অ্যাজ ওয়েল অ্যাজ প্যানেল অ্যাডভোকেট। তো আমাদের কাছে যেই মামলাগুলো আসে তারা খুবই পিছিয়ে, তারা কিচ্ছুই জানে না ল রিলেটেড। এবার যেহেতু তারা কিছুই জানে না, তারা শুধু আমাদের দিকে তাকিয়ে শুধু একটাই কথা বলে কি আমাদেরকে হেল্প করুন। সেই হেল্পটা কি হেল্প তারা জানেন না, জাস্ট হেল্প করুন। তো এবার এখানে একটা ম্যাডাম যেটা ডেসক্রাইব করলেন, এখানে অলরেডি বিএনএসে বলা আছে কি আমরা এই প্রি লিটিগেশন মিডিয়েশন হয়। প্রি লিটিগেশন বলতে কি আমাদের কেস হওয়ার আগে আমরা যাব মিডিয়েটরের কাছে, দুপক্ষ বসে প্রবলেমটাকে সলভ করার চেষ্টা করব। তো সেটা হয় প্রি লিটিগেশন। তো এখানে এখন যে প্রভিশনটা ইন্ট্রোডিউস করা হয়েছে সেটা হচ্ছে কেস হওয়ার আগে একবার অ্যাকিউজকে ডাকা হবে আর ডেকে জিজ্ঞাসা করা হবে তুমি কি এই দোষটা করেছো। তো ভাবুন কতগুলো বার্ডেন আমরা কমিয়ে দিচ্ছি, মানে আমাদের পুরো লিগাল সিস্টেমের ওপরে রোজ যেই স্যার বললেন কি এতগুলো কেসেস ফাইল হচ্ছে, সেই কেসগুলো অটোম্যাটিক্যালি কমে যাবে। তো সেই কমে যাওয়ার প্রসেস আমাদেরকে আমাদের ইনফ্রাস্ট্রাকচারের মধ্যে ইনকালকেট করতে হবে, সো দ্যাট আমরা কি করতে পারি এই যে কোর্টে রোজ যাওয়া, মানে ক্লায়েন্ট আসছে এই যে কেস, আমি নিজে দেখলাম যখন কোর্ট প্র্যাকটিস শুরু করলাম 1932, মানে তখন হাওড়া শ্রীরামপুর ডিভাইড হয়েছে, মানে সেই পজিশন, তখনকার সিভিল ম্যাটার চলছে 2012 সালে কোর্টে। তো ভাবুন কি 1932 অ্যান্ড ওর মধ্যে কতগুলো অ্যাডভোকেট সেট চেঞ্জ হয়ে গেল, কিন্তু মামলা স্টিল রানিং। তো ভাবুন এখানে যে ডে টু ডে ট্রায়ালের কথা বলেছে, এইটা খুব দরকার ছিল। আমি শুনেছিলাম পাস্ট হিস্ট্রিতে কি একদিনেই ফয়সালা হয়ে যেত, যেটা বিং আ মিডিয়েটার আমি কোর্টে করি কি হ্যাঁ আজকে দুপক্ষ সামনে বসেতে চেষ্টা করব, যদি সেটেল হয় সেটেল, নট সেটেল হলে নট সেটেল। কিন্তু সেটা এখন মানে ইন্ট্রোডিউস করা হচ্ছে কি ডে টু ডে ট্রায়াল হোক। তো পেটি অফেন্সেস, ছোট অফেন্সেসগুলো যেগুলো নর্মালি কি 100 টাকা ফাইন দিলে সলভ হয়ে যায়, সেই মামলাটা কোর্টে 5 বছর ধরে চলছে, লোকটা পাসপোর্ট করাতে পারছে না, অন্য কান্ট্রি যেতে পারছে না, ভাবুন কীভাবে স্ট্রাগল করছে। তো সেই নিয়ে আমি এসেই প্রশ্ন করলাম কি আপনারা শুনলেন, শিখলেন, কেন কি এগুলো যদি আমরা মানে আমার প্রসেস হচ্ছে কি আমি সেমিনার থেকে শুনে শিখি। অনেক সময় কি হয় কি পড়ার সুযোগ হয় না বা পড়লে হয়তো ভুলে যাই আমরা, কিন্তু শুনলে না মনে থাকে। তো সেইভাবেই মানে আপনারা সবাই সকাল থেকে এখানে বসে আছেন, যদি একটা সেশনও ঠিক করে শোনেন, সবাই কিন্তু সেম কথাই এখানে বলতে চাইছে কি যা রিফর্ম হয়েছে, যা চেঞ্জ হয়েছে, যা নতুন মডিফিকেশনসগুলো হয়েছে, সেগুলো যদি আমরা শিখে নিই তাহলে কোর্টে গিয়ে আমরা ক্লায়েন্টকে সাজেস্ট করতে পারবো। এই নাকি ক্লায়েন্ট শিখে এসে ইউটিউব থেকে আমাদেরকে বলবে কি এটা আপনি জানেন না। তো এইটাই হচ্ছে অ্যাডভান্টেজ কি একটা সেশন মানে যদি ঠিক করে শোনেন, মানে আজকে ফুল ডে যা কনফারেন্সের মানে আউটকাম যদি আপনারা বাড়ি নিয়ে যান তাহলে নিশ্চয়ই ইচ্ছা করবে কি একবার আমি মেজার একটা খুলি আর খুলে একবার পড়ি। সবার মধ্যে এই কনফিউশন এখনও আছে কি আমাদের কারিকুলাম এখনও সেইভাবে মার্জ করেনি কি আমরা আইপিসি পড়বো আর না বিএনএস পড়বো, কিন্তু স্টিল দুটো বই আমাদের হাতে আছে, কিচ্ছু মেজার চেঞ্জ হয়নি, বাট স্টিল দুটো পড়লে কিন্তু আমাদের অ্যাডভান্টেজই, ডিসঅ্যাডভান্টেজ কিছুই না। তো চেঞ্জেস নিয়ে কিছু পয়েন্ট আমি ডিসকাস করতে চাইবো যেগুলো আমি ফিল করছি কি খুব অ্যাডভান্টেজিয়াস আমাদের প্র্যাকটিক্যাল ফিল্ডে। সেটা হচ্ছে দেখুন ইনক্রিমেন্ট অফ ফাইন। তো ইনক্রিমেন্ট অফ ফাইন যাদের কাছে পাওয়ার আছে ফাইন ইম্পোজ করার, কিন্তু লিমিট দেওয়া আছে। সেই ফাইনের অ্যামাউন্টটা যদি বাড়িয়ে দেওয়া হয় তাহলে তো ডিসক্রিশনারি পাওয়ার আছে। ফাইনে মানুষ ভয় পায়, আমরা সবাই দেখি কি ওই যে খোরপোশের মামলা হয় কি খোরপোশের মামলায় যখন হাজব্যান্ডকে বলা হয় কি ডিভোর্স দাও, সে বলবে আমি ডিভোর্স দেবো না, তোমাকে এইভাবে স্ট্রাগল করাবো। তখন ওয়াইফ উল্টে যখন বলে ঠিক আছে খোরপোশ দাও যতদিন থাকবো আমি, তখন সে বলে ঠিক আছে মিউচুয়াল ডিভোর্স দিতে রাজি। তো এটা কেন হচ্ছে? পকেটের জন্যই হচ্ছে, ফর দ্য কজ অফ মানি। তো সেই জায়গাটা এখানে আমি দেখলাম ক্লিয়ার। তারপরে দেখুন কি এজেড ইনফার্ম পেরেন্টস, ওরা অ্যারেস্ট ওদেরকে করা হবে না, বা যেভাবে ইমিডিয়েটলি তাদেরকে হ্যারাস করা হয় কি রাত্রিবেলা পুলিশ 2টো নাগাদ রেড করলো, রেড করে অ্যারেস্ট করে নিল, তো সেখান থেকে রিলিফ। এই ব্যাপারগুলো কিন্তু আমরা জানলে তো ক্লায়েন্টকে সাজেস্ট করতে পারবো আপনি নিশ্চিন্তে থাকুন, কালকে সারেন্ডার করবেন, রাত্রিরে পুলিশ আপনাকে অ্যারেস্ট করবে না। যেভাবে মহিলাদেরকে আমরা বলি কি 6 to 6 তোমরা অ্যারেস্টেড হবে না, তো সেভাবেই। এবার নেক্সট এটা অ্যাডভান্টেজ এখানে বলছে কি আপনার এই যে ভিডিওগ্রাফি অফ সার্চ অ্যান্ড সিজার। অনেক সময় আমরা দেখেছি লোকজন কি বলে আমাদের কাছে এনডিপিএস অ্যাক্ট মানে কি আপনার ওই নার্কো ট্রফিক যে সাবস্টেন্সেস অ্যাক্ট আছে, সেখানে দেখবেন লোকজন বলে কি আমাকে ফার্স্টলি ইমপ্লিকেট করা হয়েছে, আমি কিন্তু এই কাজটা করিনি, আমার কাছে কিছুই ছিল না, পুলিশ আমাকে ফাঁসিয়ে দিয়েছে। তো সেই কেসেও আমরা কি দেখবো, দেখুন যদি ভিডিওগ্রাফড হয় সার্চ অ্যান্ড সিজার তাহলে এখানে অ্যাডভান্টেজ পাচ্ছে আসামি, তার কাছ থেকে কিন্তু তার পজেশন থেকে কিছু পাওয়া যায়নি। তারপরে এখানে আমরা দেখবো এক্স পার্টি জাজমেন্ট अगेंस्ट অ্যাবসকন্ডিং অফেন্ডার্স, এটাও খুব ইম্পর্টেন্ট। একটা কেস ফাইল হলো, 4 জন আসামি 2 জন পালিয়ে গেছে, সেই কেস 10 বছর হয়ে গেছে চলছে, অ্যাপিয়ারেন্স স্টেজেই চলছে। 2 জন যে পালিয়ে গেছে তার জন্য আরো 2 জন কেন স্ট্রাগল করবে? কেসটা তো প্রসিড করা উচিত। এক্স পার্টি তাদের अगेंस्टे তারা পালিয়েছে জেনে শুনে কি হ্যাঁ ওরা বেল নিয়েছে, ইভেন ওই মামলায় বেল নিয়ে গায়েব, তো সেটা চ্যালেঞ্জ। তো সেই জায়গা দেখুন এখানে ক্লিয়ার করা হলো, যেটা আমি খুব খুশি হলাম কি অনেকজনকে রিলিফ দিতে পারবো কি ঠিক আছে ওদেরকে মানে ওরা ওদের শাস্তি, ওরা নিজেকে ডিফেন্স করতে আসছে না, তারা শাস্তি ভুগবে, তোমরা ডিফেন্স করো, এগিয়ে যাও। আর একটা লাস্ট এখানে দেখুন যেটা আমি অলরেডি ডিসকাস করলাম কি ডেইলি বেসিস ট্রায়াল, আর একটা হচ্ছে উইটনেসদের প্রোটেকশন। কোর্টে যেটা দেখবেন সব থেকে খারাপ লাগবে সেটা হচ্ছে সাক্ষী স্ট্রেচারে করে আসছে সাক্ষী দিতে, না হলে ওয়ারেন্ট হয়ে যাবে। অলরেডি কোর্ট না দেখে ওয়ারেন্ট ইস্যু করে দিয়েছে, সাক্ষীকে স্ট্রেচারে করে নিয়ে আসা হচ্ছে, যেহেতু ওয়ারেন্ট একবার ইস্যু করে দেওয়া হয়েছে তার সলিউশন কি বেল নিতেই হবে তাকে। তো এই প্রভিশনগুলো বেসিক আজকে ওভারঅল আমার খুব ভালো লাগলো, আর আমি চাইবো কি আপনারা গিয়ে বাড়িতে এগুলো ডিসকাস করুন, পড়ুন আপনাদের মধ্যে। আর থ্যাংক ইউ সো মাচ।
Thank you, ma'am. Now I would like to call Mr. Boshupriyo Chattopadhyay, student of School of Law, Sister Nivedita University, Kolkata, to come up to the podium and present his paper on the topic Aligning Forensic Investigation Practices within the Framework of the BNSS. a path forward.
Good afternoon to all the respected faculty members present in the dais and off the dais. The topic of my presentation is aligning the forensic investigation practices within the framework of Bharatiya Nagarik Suraksha Sanhita, and I would discuss that how it is important in each and every day scenario. First of all, in the very recent context, we all have heard about this Arjikor case. We all are aware of the facts and other things. In this case, we know that forensic experts are playing an important role, right? Now, forensic science, rather this term forensic science has been proposed in modern scenario in much larger aspect in the earlier 10 years. Now this term has been developed through a terminology that criminal always keeps something behind. And this is not my word. This is the word of Sir Edward Lockhart, who was an American criminologist, as you can see in my PPT. Now, the evolution of forensic investigation in India is also not from this 21st century, but from the colonial era. And most importantly, if you notice that India, in Bengali what we say, that বিশ্ব সভায় ভারত একটা মহান জায়গা পায় বা এরকম একটা জিনিস আমরা সবসময় ভাবি, that is very true, because India always leads from the front. And this evolution of forensic investigation in India, as per the report of BPRD, it tells us that India is always leading for having the development of forensic investigation in the criminal justice system. Now, why I am going to discuss about BNSS, but prior to BNSS, I would like to point out that there are, or rather there were, other statutes that focused on the implication of forensic evidence, not directly but impliedly. First one, the Indian Evidence Act. We all have heard about the expert opinion, right? Section 45, Section 45A, right? In the Indian Evidence Act 1872. That impliedly says about the implication of forensic evidence. In CRPC, Section 164A, the medical examination of a rape victim, that also impliedly deals with the implication of forensic evidence. And also, importantly, many of us don't know about a bill. Obviously, the respected faculties note, but the student discusses about it. That is the DNA technology bill that came in the year 2019. The full name of the bill is DNA Technology Use and Application Regulation Bill of 2019. Though this bill have been repealed, but this bill particularly focused how we can use DNA for proper investigation in the criminal justice system. Now I would focus on some case laws. First of all, in Gautam Kundu versus State of West Bengal, this is a case of 1993. In forensic investigation, there is a procedure, that is Y chromosomal analysis, to determine the paternity of a child. In this case, Honorable Supreme Court pointed out through Y chromosomal analysis that who was the actual father of the child of this particular case that dealt with. And most importantly, we have not forgotten the case of Nirbhaya. In this case, Supreme Court pointed out that how important it is to have a direct implication of forensic evidence in the criminal justice system. And as a result of that, not impliedly but directly, we have the provisions of forensic science or forensic evidences in BNSS, Bharatiya Nagarik Suraksha Sanhita. The way I explained on my previous slides are the evolution, how we came to BNSS. And now, the BNSS part. Most of us have discussed about the section 176.3. So 176, section 176, subsection 3 of BNSS. And as respected Professor Dr. Debashree Mukherjee pointed out that this BNSS is a victim-centric law. But when we are discussing about this forensic evidence or forensic investigation, the way, as correctly pointed out by ma'am, that the way we need to implement, or rather what was the motive of the legislature to implement this particular provision, was to gather evidence for prosecution and to give justice to all, not the victim, but also if anyone is upon the fake case, then accused, that fake accused also need to have a proper justice through NAY, right? So apart from section 176 subsection 3, we also have other provisions of BNSS, section 349, where there is a power to magistrate to offer forensic sample collection without prior arrest also. This is very important, section 349 of BNSS. So, if this procedure continues, then what would be the discussion of these issues and challenges in new criminal law? Then BNS is okay about all the forensic evidences, but there are challenges. Very near to my institution, Sister Nivedita University, there is a CFSL lab, Central Forensic Laboratory. And the recent data says that there are 7 central forensic laboratory in India, 32 state forensic laboratory, as well as there are other forensic laboratory which accounted to more than mere about 650 or 700 across our country. Now, as per a statement made by our Honorable Home Minister in Parliament 2023, I quote, India will need 90,000 forensic scientists in 9 years, unquote. So this is the first challenge which I would like to point out, that though we are saying that we need proper forensic investigation, we need to have proper implementation of forensic evidence to give proper justice in criminal justice system in our country, but we are lagging. We are lagging from experts, we are lagging from our manpower. And in a very recent report that was published in Times in Hindu, that Union Cabinet Minister particularly pointed out that Government of India would spend near about 3 crore for the development and training purposes of the forensic experts. And if this can be done, then this chain would not be there in upcoming future. And as a result of that, at the very ending note, I would like to say, if we enhance our forensic infrastructure, if we build proper training capacity, and also if we get this collaboration of the agencies and forensic experts like CBI, CID, along with the forensic experts, this collaboration need to be done for the proper evidence purpose and proper dealing with the matters. Then, in coming future, India would be there, what Swami Vivekananda once said, that Bahujana Hitaya, Bahujana Sukhaya, that particular term would be properly implemented in the criminal justice system of our country. Thank you.
Thank you. Now I request Dr. Sarfaraz Ahmed Khan, sir, to wind up the session with his concluding remarks. Please, sir.
Okay, good evening, everyone. So I have two jobs. One, to give some kinds of concluding remark of the two technical sessions which happened now, and as well as to present the thing which I supposed to do as per schedule. So the so far concluding one is concerned. Thanks all the panelists for making excellent presentations. So you're already here, so we know the time, paucities of time. I'll go directly to the thing which I want to present, and the title which I given of my presentation was the BNSS Bharatiya Nagrik Suraksha Sanhita, what we have failed to achieve from this law. Now, let we clarify first. From morning we are hearing that we have to get rid of this British hangover, colonial hangover. CRPC was 1973 law. It was more Indian than the BNSS. Why so? Because the amount of time deliberated on the passing of CRPC was far, far, far greater than the time taken for the passing of BNSS or consultation of BNSS. So the Indian representative, the amount of time they devoted in CRPC was far wider. So it is more Indians, they are able to deliberate, they can talk about it. So it's not the colonial hangover. CRPC was not at a way it was a colonial hangover. We have passed the law in 1973. In fact, when we see the legislation on procedural law of the different part of the world, they all use the words criminal procedure. For example, Criminal Procedure Act 1977, South Africa. Criminal Procedure Rules 2020, United Kingdom. Federal Rules of Criminal Procedure, USA. Criminal Procedure Act 1986, Australia. Criminal Proceeding Rules, Canada. The Criminal Procedure Ordinance, Hong Kong. So that throughout the world, when they divide the procedural law and substantive law, the Act objective clearly says a criminal procedure. And by changing that Nagrik Suraksha Sanhita, it does not make any sense. Neither it is for Nagrik Suraksha, nor it is for the accused Suraksha. So it's 95% almost same what was in the CRPC. Some places they have made change. But what they have not done, or what they have done injustice, I wanted to talk to on those few points. First of all, what they have not able to achieve is ensuring in the real sense right to speedy trial. We remember Supreme Court consistently says right to speedy trial is a fundamental right. You have legal aid cases like Husna Ara Khatun, other cases where this is right to speedy trial. But more importantly, there was a Supreme Court judgment, specifically A.R. Antule, 5 judges bench decision. It says right to speedy trial is a fundamental right under Article 21. Common Cause 1, speedy trial is a fundamental right. Common Cause 2, speedy trial is a fundamental right. But none of those laws dare to fix the time limit within which we complete the trial. So one of the panelists was saying that the time we taken for completing the trial in criminal cases is the same thing today also. So it takes 20 years, 25 years, but there should be some time limit in which the trial can be completed. What happened in 1999, there was a case called Rajdev Sarma, and in Rajdev Sarma first case, the division bench of Supreme Court was dare to fix a time limit, and they says criminal cases must have a time limit within which you should finish. If you don't finish within 3 years period, the case will go to next step. CBI went in appeal. In Rajdev Sarma 2, Supreme Court clarified that it is a delay because of the accused, those time need to be expunged, and then the time will be calculated 3 years period. So from 1999 and 2000 it was reported, second was 2000. From that point of time till 2009, Rajdev Sarma was ruled. But the time comes in the year 2009, when there was another Supreme Court judgment, it's called P. Ramachandra Rao. And P. Ramachandra Rao, Supreme Court did not go into merit. Had they gone into merit, there's a different questions. The P. Ramachandra Rao went on technical issues. And the views was that A.R. Antule, 5 judges, has not dared to fix the time limit. Common cause, 5 judges, has not dared to fix the time limit. How can you division bench fix the time limit? So on technical ground, P. Ramachandra Rao has set aside Raju Sharma 1, Raju Sharma 2. Now issue comes, because of the technical ground it was set aside, when we are coming up with a new law, it was an opportunity for us, if the right to spirit trial is really makes sense, they must have come with a time limit. There are some places they have fixed the time limit, charge can be in 60 days, after argument 45 days, discharge application 60 days. So they have fixed sporadic some time limit, but that does not going to make change. You must have, if the right to spirit trial is a fundamental right, you must have a framework within which the trial can be completed. So this law failed there. Second failure of this law, or what I think the worst thing which this law has done, I normally say is the worst disservice to the criminal justice system. What this law has done is denying to access to justice, or weakening the access to justice of the citizen of this country. How they did it, let me explain. I believe many of you have done already CRPC. In the CRPC, the criminal cases start with 3 processes. First process to start criminal cases is registration of FIR. So in the old law it was section 154 CRPC. In the new law it became 173 BNSS. The second process is, when FIR is not registered, someone can go to the court and court can direct the magistrate to register under 156 clause 3. So that become under the new law 175 clause 3. The third process to begin criminal case is filing a complaint. It was 200 CRPC earlier, now become 223 of BNSS. Now what the disservice this law has done to the common people? In the FIR, they added second clause where they says that in cases where punishment is up to 7 years, police, instead of registering FIR, they can do preliminary inquiry. For what purpose? Preliminary inquiry for the purpose of ascertainment of whether there is a prima facie case exists or not. Now, where we used the prima facie case earlier, traditionally the word prima facie case has been used in respect of determination done by the magistrate, by the court. So when court frame the charge, it is on the basis of prima facie case. When court take cognizance on the basis of prima facie case, the kinds of a determination which judicial magistrate used to do, now we are expecting that police, instead of registering FIR, they will determine in cases where the punishment is 7 years, that okay, without FIR they will do primary facie cases there or not. Sometime argument is raised that okay, Supreme Court in Lalita Kumari case says of the preliminary inquiry. But where the distinctions? The Lalita Kumari, when it says prima facie case, it says about the preliminary inquiry, it says preliminary inquiry to determine whether there is a cognizable offense or not. This is not prima facie case. So the only margin which available according to Lalita Kumari with the police was that police must be satisfied that there is a cognizable offense, but if police is not satisfied about the cognizability, then they can do preliminary inquiry and then once satisfied they registered FIR, not on the merit, whether the statement revealed cognizable offense or not. Now in village area where poor citizen does not even dare to visit the police stations, we want them to move from one after another to the police station to register FIR, and then police can say we are doing preliminary inquiry. Which police? You remember after independence from beginning till now, police commission says police don't register FIR. Even police commission's reports are the reason for which the police don't register FIR. Police commission says extraneous influences and corruption that operate on the system and disinclination of the staff to take on additional load of investigations work. Is a police commission is saying, not outsider, that police don't register FIR. Malimat committee says police don't register FIR. Law Commission says police don't register FIR. So we know there is a large number of dark figure of crime. The same police, when there is a mandatory requirement that you shall register FIR, they don't use to register FIR. When we give them margin that, okay, you do preliminary inquiry, instead of registering FIR, where the poor Indian will go? So the villagers will be worst sufferer in this situation. And the disservice, first circumstances. Second, 156 clause 3 which was there, that become 175 clause 3. Those who are aware of 176 clause 3, what the system was earlier operating was that if police don't register FIR, a citizen can go to the magistrate, they say the police has not registered FIR, magistrate will direct the police that you registered FIR, investigate the case. Now it says that before directing for FIR, magistrate must hear that police officer. That a police who is not registering FIR, they will ask for call for report. Now when you ask for call for report, if nothing happened, it will kill 10 days time. Suppose a kidnapping case, a family went to the police to register FIR, police is not registering FIR, that family go to the court and the court will say, okay, I will call for report from the magistrate, because without which they cannot direct. Where the poor Indian will go? So it is not really making the things active. That again, this service. Third thing in complaint. But in the morning, someone has raised issue about the pre-cognizance hearing. Now, in the complaint case, someone goes to the court can hear the complainant, hear one or two witnesses to satisfy there is a case is made out or not, prima facie satisfaction, and the court can issue summon. As soon as summon is issued in 204, that means cognizance has been taken. Now under the new law it says, provided that the magistrate shall not take cognizance unless opportunity of being heard given to the accused person. So in one trial we are having second trial, mini trial. Now these three provisions, which basically the way the criminal cases start, we are creating hurdles for the poor Indian, is the biggest disservice which this law has done. So what we were saying, good thing, colonial, etc., it is the disservice which is done to the Indians. That's the first thing. Many times we raise the issue. In the morning also someone says about the EFIRs and the without jurisdictions. What the word EFIR they said? It says the officer in charge the FIR shall be recorded on, it shall be taken on, the wording is, it shall be taken on record by him is officer in charge, on being signed within 3 days. Impliedly, if you send by email, within 3 days you will go to the police station, you will sign the formal FIR, then FIR number will be done. Is it EFIR? EFIR concept should be that if I am filing FIR, there must be system, I will sit in the computer, I have my detailed signature, I will sign there, FIR will be registered. So if before this law, when we used to send email or SMS to the police, the same thing would happen. The police used to call the persons, prepare the hard copy, they sign it. So what was the system earlier? The same thing is there, nothing changes. The way it is being portrayed as EFIR, that really the things has been, magic has come and the EFIR is registered. EFIR in real sense it will become EFIR when we develop the system where the people can register FIR sitting at their home. That also, I think, some kinds of a misnomer which are being spread, that changes has been done in the law. In that way, there are many things in the law which they have done where they have changes in the provisions. There are some smaller omissions are also there. For example, in section 35 clause 3, Supreme Court categorically says the notice period should be 14 days. There are many cases where court has said that has not been included. So these are the smaller. There are many places there are omissions. In that way, there are another places when it says one of the best thing, okay, that's I said what the worst thing they have done. The best thing BNSS has done is inclusion of section 105, where the police can do, when they do search and seizure, they will do videographies by audio, video, electronic means. Excellent provisions. But where it apply? Why it was included? It was included to avoid any kinds of argument or planting of evidence. So the always issues come that police when do search, etc., there might be a planting of evidence, or at least defense can argue that there was a planting of evidences. So once you have by audio, video, electronic means there is no chances of planting. Excellent provisions. Where it apply? It applied to search and seizure conducted in the chapter of search and seizure, which include 94. So when police ask someone to submit the document, it apply there. It do apply to section 185, 186. So when police do search without warrant or with warrant. But it does not apply to search and seizure which was done after arrest. So when a person is being arrested and his body is searched and some contraband article found, the seizure is being made, it should apply there also. But they have not mentioned that section. Impliedly, we have taken care of planting of evidence when search and seizure done by virtue of search and search warrant or without search and search warrant. But we leave the option open when police do planting when people arrest someone. So we are keeping the options open. While there is judgment of the Calcutta High Court in NDPS cases, the High Court categorically says you must do video recording. So the provision of 105 should also extend to when search and seizure conducted after arrest of the accused person. That's the another gap which exists in the law. 107 most dangerous provision under BNSS. We don't have any much time, otherwise I could have explained the provisions why they have deleted it. 144A they have deleted. I don't think it was a right time to delete 144A CRPC. 172 which they have added again. I suggested for things. One thing which I'll suggest all of you, all the students and all the panelists, Government of West Bengal has formed a committee. The committee's details are available on the website. Those who presented today, please send your suggestions to the committee formed by the Government of West Bengal. Whatever you think about the provisions which you want to retain or delete or add and alter till 31st of August, that means another tomorrow, might be they're going to extend also. But you can submit your report to the committee and you can ask them to take some measures so you can contribute in that. Another thing, there are many things which I wanted to discuss, but we don't have that much time. One thing which always I wanted to say is about, we have discussed about the in absentia trial of the proclaimed offender. Now, I just want to share one example. During the British regime, so it was old CRPC, not even 1973 CRPC. In the old CRPC regime, suppose a person is being convicted, he is in jail. In that point of time, there was a practice that if the appeal will be filed through the jail inspectors, etc., in the higher court, in the high court, and as a practice, if the high court will peruse the entire document and they found that appeal has no merit, etc., it will be deemed to be considered as a hearing without giving opportunity of the accused to either present himself in the court or present through lawyer. Now that was the situation pre-independence period. In that point of time, there was a judge called Justice Sayyid Mahmood. He was a Uttar Pradesh judge, so there was a 5 judges in High Court at that point of time. And that continuous practice was very offended with that. So he given a dissenting opinion in a case called Queen Emperor versus Pohpi. That was the case name, Puhpi. The case was 1891, it's reported in Indian Law Report. In that case, he said that if the accused either himself is not appearing or his lawyer is not appearing in the court, it cannot be considered as hearing. So he said either accused must be given bail or allow from jail to appear his persons. Unless he see them, he will not pass the order. So he says hearing means must be constructive hearing, not only seeing the document. Now, the result was, subsequently he was resigned from the court because after this dissenting opinion, he said, I will not part any order unless I find either accused in my court or I find some representative. So that point of the Chief Justice has started not giving any assignment to him. So these kinds of criminal cases he was not getting thereafter because of his dissenting opinion. He is famously called the dissenting opinion judge of the colonial India. Why? Because the substantive hearing was not given. That judgment was referred to just recently, few years ago, in a case called Kalwa versus State of Uttarakhand, and it's a 2018 SCC. The reporting is there. Uttarakhand judgment, SCC online. Case name, again I am saying Kalwa versus State of Uttarakhand, where the court has referred to his judgment, dissenting opinion, and says that was correct. We must give opportunity of heart to the accused persons either through himself or through a representative. If he is not appear, it's not a hearing. Court has acquitted the accused, discharged the accused who was convicted by the lower court but has not given effective opportunity to representative. So in colonial India, what practice was there, dissenting judgment has changed it. He attempted to decolonize. Now in modern India, we are colonizing it. We are going back to same system what Britishers was following that point of time. We are starting in absentia trial. How far it is justifiable, I don't know. Particularly in cases where someone is not appear in the case from beginning. So there could be two situations. Someone appear in the court, face the trial, in between jump. He knows about the case. But some accused who never appeared, he doesn't know about the case. Can we conduct in absentia trial? Is it not violative of fair trial principle? What is that? Here the hearing means, what the opportunity means. So it's not only cosmetic hearing, it's not only cosmetic representation, but it must be fair hearing. It must be fair trial. It must be effective representation. So I hope some of the colonial laws which they have done, we should not follow it now. What they have not done, we should not introduce now to create more hurdle for the citizens of this country. Many things which they themselves has not done. In complaint cases, they have not started the procedure. The same thing what was there in the earlier last century CRPC. FIR, the similar thing was there. Now we are creating hurdle in the accessing to justice. So you have to decide whether really we have decolonized or we are recolonizing to the old British systems where the Indian citizen was facing difficulty in getting access to justice. Now we got law, we cannot change it. But at least some state is attempting to make some amendment. So be party to it, assist them, suggest them wherever you think it's appropriate. The remaining main provisions are same. So with these few words, I thank to Haldia Law College for inviting me. Due to the paucity of time, I had many things to discuss what the changes are there. But these are the few points which I wanted. You must know about these provisions where really, and you decide yourself what we can do. In some places, as the discussion has not been made, I just want to make one more point on the Sakshi Adheniyam. We got amendment in the Sakshi Adheniyam. We got 57, primary evidence, 4 explanations. Excellent, I am not criticizing it. Where the difficulty comes is, along with these, legislature wanted to make it simple. But while making it simple, they have make it more complicated. How they have done it? Now, what the 63 requirements are, there are 2 certificates. Certificate A at the time of seizure, certificate B by the expert. Now, in criminal cases, we can understand police is there, prosecutors are there, systems are there. But same evidence act apply, Bharatiya Sakshi Adheniyam apply for civil cases. So suppose husband and wife has a divorce matter where husband has sent message to the wife or wife has sent message to the husband and they have in WhatsApp chat which they have saved in the computer. They wanted to transfer in pen drive. If they want to admit in pen drive, they have to make the same certificate. They have to send this thing to the expert. Now which expert, from where they will get the expert? So we created it, the same standard we have created for criminal cases, the same standard we have created for civil cases. It will create challenge when we try to implement it at the grassroots level. So if rigidly we will apply 63 certificate for civil cases, where is the infrastructure? Who will give the certificate B? Who will file the certificate A? Even I cannot fill up that form because it's required to find out has value. I don't have that software. So if a literate persons cannot do, how can we expect the villagers, etc., they can follow the same procedure and able to admit those digital evidences? So it's a very good foolproof system for maybe criminal cases. But the same law applied to civil cases also. So hope the court can come up with something. Already court has started interpreting. The worst thing they have done is about the last section of both the law, BNSS and BSA. They says for all cases they will apply old law. For new cases they will apply new law. Criminal cases may be disposed of in 20 years. Civil cases may be another 50 years. So we are not getting to get rid of Indian Evidence Act. Now some good sense has prevailed. Now recently, one of the High Court says that some beneficial provision will apply to old cases also. Hope they will interpret and judiciary can pass some order by which they can make these provisions applicable in the old cases so that we can get rid of this difficulty that for one cases we are taking Indian Evidence Act, for other cases we are taking BSA. We need to get rid of this silence. So with these few words, thanks everyone for hearing me. Thank you.
Thank you, sir, for such an invigorating speech. We are at the edge of the segment, which will be concluded by Dr. Pratim Sarkar, Sir, Associate Professor, Haldia Law College, with the delivery of vote of thanks. Please, sir.
Hello. I feel honored and privileged to get an opportunity to propose a vote of thanks in this national seminar. First of all, I would like to propose cheerful vote of thanks to our chairman, sir, Dr. Lakshman Chandra Seth, for delivering his valuable speech in this program. His presence today in this function has immensely enhanced its importance. I must mention my deep sense of gratitude to the Vice Chairman, Mr. Sudiptan Seth, and Secretary of HLC, Mr. Bimal Majhi, learned advocate of Haldia Court. We appreciate their constant support and cooperation for running this college in a healthy manner. I, on behalf of Haldia Law College family, extend a very hearty vote of thanks to the resource persons and delegates who blessed us with their presence and took out valuable time for their busy schedule. I express my deep sense of gratitude to our distinguished resource person, Honorable Justice Madhumati Mitra, former Judge, Calcutta High Court, Honorable Justice Tawfiq Uddin, former Judge, Calcutta High Court, and Academic Advisor of Haldia Law College, Professor Anirban Chakraborty of India International University of Legal Research, Goa, Dr. Sarfaraj Ahmed Khan, Associate Professor of NUGS, Kolkata, Dr. Devashree Mukherjee, Dean, School of Law of Sister Nivedita University, Kolkata, for giving excellent presentation and making this seminar interesting and meaningful. I am happy to express vote of thanks to all the distinguished speakers for giving their valuable presentations. A particular mention goes to our esteemed principal, coordinator, co-coordinator, and seminar committee members for their valuable advice, guidance, and untiring efforts. Finally, I take the opportunity to express sincere thanks to all the faculty members and administrative staffs for their tireless work and making this event a successful one. In the end, I am very much thankful to all the students, volunteers, and the people who are working in the background. They all help us to make this event a great success. Thank you very much. Have a nice day. Thank you.
Thank you, sir. Now we are proceeding towards our valedictory session. We would like to honor our esteemed guest with certificate and a small token of appreciation on behalf of Haldia Law College for making this seminar a success. For the same, I would request Dr. Shamit Kumar Maiti Datto, sir, Principal, Haldia Law College, to do the honors. Thank you, sir. Thank you, Anirban sir, for being with us. Now, Sarfaraz sir is going to be honored. Thank you, sir, for your presence. Now, Deboshi ma'am is being honored. Thank you, ma'am, for your precious time.
Now, we would like to present a memento and certificate to the paper presenters of this seminar. For the same, I request them to come up on the dais. I request our distinguished resource persons of the seminar to do the honors. Dr. Tamal Gupta, please come to the podium. Please come to the dais. I request Professor Dr. Anirban Chakraborty sir to do the honor. Mr. Victor Nayak, please come to the dais. Again, I request Professor Dr. Anirban Chakraborty sir to do the honor. Dr. Pradipta Barman, please come to the dais. I request Dr. Sarfaraz Ahmed Khan sir to do the honor. Mr. Akrit Shah and Ms. Snehashri Goswami, please come to the dais. I request Dr. Sarfaraz Ahmed Khan sir to do the honor. Learned Advocate Yasmin Khatun, please come to the dais. I request Professor Dr. Debashree Mukherjee ma'am to do the honor. Mr. Boshupriya Chattopadhyay, please come to the dais. I again request Professor Dr. Debashree Mukherjee ma'am to do the honor. Thank you, everybody. Thank Thank you. I heartily thank the resource persons for coming here, sharing their knowledge with us, and making this program a grand success. Thank you. A small students, do not leave the seminar hall. There is an announcement for you. All the students, all the participants of this seminar will receive a certificate of participation. You will collect the certificate next week from Nirupam sir. Secondly, an announcement for the staff. Tomorrow, Saturday, that is Saturday, will be a holiday for all the staff of Haldia Law College. Thank you. Now please maintain decorum and silently leave the hall.